I'm joined by Dean Robert Leckey, Dean of the McGill Faculty of Law. Thank you so much for joining us.
My pleasure.
I want to speak to you about the Bill 21, what the decision was that came down today. Some parts of it struck down, others upheld. So I want to know from you what exactly it means for all Quebec citizens, especially those affected by this.
Sure. So what the court said today is that Bill 21 doesn't apply to the English language school boards of the province, and it doesn't apply to elected members of the legislature. So much of the rest of Bill 21 continues in force, and we'll see the groups that didn't win today have already indicated that they're wanting to appeal to the Quebec to the next stage of court.
So there were people who, I guess, lost and won today. Describe those, I guess, parties. For the majority, it's still business as usual, but some groups can go ahead and change their ways.
Well, it's only the English language school boards really for whom it makes a concrete difference today. They'll be able to hire teachers wearing headscarves or kippas, other religious symbols. They'll be able to promote teachers, to vice principal or principal. But it's really a defeat for most of the challengers. So the groups representing particular religious groups, Jewish lawyers, Sikhs, Roman Catholics who want to be able to show a religious symbol while working in the public service, it's a defeat really for all of those groups.
The exemptions that were made for those who work in the National Assembly and the English sector, why were those exemptions made? What was the basis of that?
Well, the reason, a lot of the action in the judgment today focuses on the Canadian Charter, and the Canadian Charter has what we call the notwithstanding clause that allows the legislature to make a law operate even if it violates rights. But the notwithstanding clause can't apply to the whole charter. And so where the judge found the law not to apply, it was based on provisions that can't be touched by the notwithstanding clause. So the right to run for elected office, that can't be touched by the notwithstanding clause. And the right for the English minority school boards also outside the notwithstanding clause. So the judge basically said, look, the province has substantial power to override rights, but not for the schools and not affecting elections and elected office.
On what ends do you think that the Quebec side of it, the government, will appeal this as well to the English sector and the National Assembly, and also the minority groups that did not, as you mentioned, win today? Do you think they will be appealing?
The judge rejects pretty soundly the province's arguments, arguing that it should apply to the English school boards and elected members of the legislature. But for the groups that have indicated they want to appeal, they had a number of very, very solid arguments, I think, that they would like to have heard by the Court of Appeal. There are a number of constitutional resources outside the Charter, and they based arguments on those. They made some arguments about the notwithstanding clause in the Charter. And it's fully foreseeable that the Court of Appeal might view these things differently, or the Supreme Court eventually. So this is not over yet.
Thank you so much, Dean Leckey.